This video on week 4 is going to conclude our discussions on medical assistance in dying. And when we left, we were just talking about the legal challenges to medical assistance in dying, noting that some have been challenging to open it up, saying the legislation is more restrictive than it needs to be, that the interpretation needs to be built out to be more inclusive. And really one of the biggest points about this really is the focus on the complete prohibition of advance consent. Now, throughout this course, we've talked about the requirement of a person to understand and appreciate and be able to have mental capacity to make decisions on their own. And that's the basic premise for healthcare consent. It's the premise as well for being able to make a power of attorney, or in some jurisdictions, a representation agreement if it's for your health and personal care decisions. In the other jurisdictions, it's power of attorney for personal care. So we know how critically important it is for the ability to understand and appreciate in order to make your decisions. Then there is no real sort of advance consent in most jurisdictions, but for a few, and I'll use British Columbia as an example, which has advance directives, and Nova Scotia has new legislation on healthcare directives as well. And advance directives are different than a typical type of power of attorney type of consent. They speak directly to the third-party healthcare provider without going through somebody else's thought process first, or proxy decision maker. So in the case of where the jurisdictions allow for advance directives, or sometimes called healthcare directions, which is not Ontario, they are a document that stands alone, and you can say I do or I do not want something, and then have it appropriately signed and formalized, and that will go directly to the healthcare provider. It's quite dangerous in some cases, however, as some people will pick out, because it doesn't have a person necessarily to interpret the values, wishes, and beliefs. So you may say, I would never want to be on machines or respirators, but then actually in real instances, you may only need to be on a machine or respirator for a week or 2 weeks, and yet there's no kind of wiggle room or somebody else to reframe that or provide contextual understanding. So some people are very against advanced directives or advanced healthcare directives, and they are mostly not what the law is in this country, with the exception of a couple different jurisdictions. So when we're thinking about, the notion of advance consent, it kind of builds off that idea of advanced directives. We use the term living wills as kind of a slang. There's no such thing as a living will in Canada. Usually when we're talking about that, we're talking about some type of advanced care planning process. And as I say, in a couple of jurisdictions, we may in fact be talking about that standalone document. So Dying with Dignity is one of the organizations that was pushing very strongly to allow for advance consent, particularly for people who will be losing their mental capacity as an inevitability at this point from the disease of which they are dying. The biggest one, of course, being Alzheimer's or related dementias. Until recently, the Alzheimer's Society of Canada had come out quite strongly against advance consent, saying it was just too uncertain and not enough clarity or protections around that. The Alzheimer's Society of Canada has now taken a step back and saying it's reconsidering its position about advance consent. So at this point, it's still thinking. It has not yet come out for or against. It is really important also, as I say, to understand that there are people who are trying to narrow this. And again, that Foley case is the person who has serious neurological disabilities in Quebec, and he's saying that essentially medical assistance in dying, assisted dying was what's being pushed on him, and he had recordings as well showing the fact that people were, in this particular case, offering assistance dying, and he was saying, no, what I really want is assistance to live. So I'm now on the slide of other options, which we will see as slide 16. So some of the other options to medical assistance in dying includes withholding or withdrawing life-sustaining treatments. So people with mental decision-making capacity, again, people who themselves can consent, have the right to refuse treatment. This is well established, even where the refusal will result in death. And quite often this also sometimes will extend itself to refusing to eat or to take nutrition. And it's important that mature minors and individuals who may have a mental disability or a mental disorder, but who still have decision-making capacity, may also make the right to withdraw or withhold life-sustaining treatment. And this is also important, as may a substitute decision maker if they lose decisional capacity. So this is quite different than medical assistance in dying, where no substitute decision makers are allowed and there is no advance consent. And at this point, mature minors or people with mental disabilities would not qualify. So this is a different area. Unfortunately, or fortunately, depending on your point of view, withdrawing or withholding treatment is a prolonged process, and some people would say a very difficult and painful one depending on the circumstances. Turning to the next slide, slide 17. So we have CPST, which is often known by that acronym, but it's continuous palliative sedation therapy. And so this is giving sedation until the person dies from the underlying illness. And there's a bit of gray in the interpretation of CPST because the amount of time in advance of imminent death is a little flexible. And one of the debate points, one of the concerns is that where people who may not be able to qualify for MAID, they may end up kind of moving into this CPST and get sort of continuous palliative sedation. In practice, it's usually done without any kind of artificial hydration or nutrition. And this is, again, clearly legal with there is an imminent death. But whether or not it is appropriate in law where death is not imminent is quite still unclear. Another option, moving to slide 18, is voluntary stopping of eating and drinking. Again, this is just a very kind of plain language idea. If you're mentally capable, you can stop. And where provinces like BC, for instance, say, you can have an advance directive, this type of document that doesn't require a proxy substitute decision maker, you can actually have a VSED written within that. Sometimes it's used or seen as a pathway to MAID. So you could refuse food and water for a few weeks in order to become eligible for MAID. So it feels like it's a little bit an end run around qualifying for MAID in some cases, people will say. Again, it's an area of debate and a very contentious area of debate for some people. Again, it's really important that the Health Care Consent Act is front and center when we're thinking about these issues of mental capacity and the ability to make decisions about end of life. Right now, what we know is overwhelmingly, if you are going to be looking to have an end-of-life procedure, the issue of mental capacity and who gets to decide really is within your own hands. That, of course, being quite limited for people who are dying and have a mental capacity issue. And again, often in the cases where there is a mental capacity issue, you may end up looking at something like withdrawing or withholding treatment or continuous palliative sedation. This is an evolving area, and as you see, there was a fourth report provided by the government committee, which has been seized of looking at the issues of medical assistance dying, and that came out on April 25th, 2019, and is part of your materials. So I don't think we're at the end of this. This is really going to be the beginning of a broader legal challenge to the interpretation of medical assistance in dying. And again, I think it's quite important to know that the Alzheimer's Society has taken a step back from its position, which was against medical assistance in dying for people with dementia, and is now saying it's reconsidering its position, and at this point has not come out with the position. I hope this discussion of medical assistance in dying has been useful, and again, remember, in the end, it really is about who gets to decide, who gets to make these decisions, and overwhelmingly in end-of-life decisions, it really does tend to be the person who's capable, and in narrow circumstances, it will only then be a substitute decision maker.